And I'm delighted to welcome Russ Mead. Russ Mead is the Shared Earth Foundation visiting professor at Lewis and Clark Law School. Russ is a popular lecturer nationwide who uses examples from his career as general counsel for animal rights organizations to illustrate animal welfare and other animal-related laws. Russ has served as general counsel for two of the best-known animal sanctuaries, Best Friends Animal Society and Farm Sanctuary. He also served as Farm Sanctuary's interim executive director. Russ also has experience implementing and managing large-scale animal rescues, including during Hurricane Katrina. He's been involved in animal hoarding cases, each involving hundreds of animals. Russ's legislative advocacy work includes grassroots organizing, lobbying, and media promotion. In private practice, Russ has represented animal nonprofits in tax matters, intellectual property disputes, employment issues, fundraising compliance, and nonprofit formation. On a personal level, Russ raises awareness of animals by attempting to capture their spirit in ink wash paintings, which some of us have and are super awesome. Russ holds a JD from St. Louis University School of Law, an MBA from Lindenwood College, a BS in accounting from Arizona State University, and earned a CPA license. Russ is also the author of 3 textbooks: Nonprofit Animal Law, Farm Animal Law, and most recently, Trial Advocacy in Animal Law. Please join me in welcoming Russ Mead.
Thank you very much. So a few things. I look at a room this size, and I was here this morning when it was filled, and we had the students. Of course, a lot of the students have left. It's just amazing to me that there can be this many animal lawyers, animal rights lawyers, people who are interested in animals. I mean, it just boggles my mind considering where we were just a few years ago. For those of you who are new to this, let me just say, and I say this every time I can, this is the golden age of animal law, animal rights, animal advocacy. If you look at the things that collectively the folks in this room and others have accomplished in the last 10 years, it's greater than it's been in the last 100. And so this is the time to do the work that we do. Now, this is a professional responsibility presentation so that we can all get that CLE credit that we all need as practicing lawyers. And the program is a little different than ones you've seen before, unless you've seen me speak before. This is the way it works. I create this hypothetical of this animal rights lawyer who has a normal practice. So she's always has a traditional practice, but she is one of us. She works as hard as she can to help the animals, and she does it with so much vigor, let's call it that she kind of forgets about the rules of professional responsibility. I mean, they all go aside when she's out trying to help the animals. And I do this in the funniest way I can think up, and it's not subtle. This is not a law school exam where you're picking through the fine words. When she violates a rule of professional responsibility, you will know it. And the reason that we do that is to remind you when you find yourself in a situation where one of these rules has come into play, you can say, oh yeah, there is that crazy woman that was doing these things, and am I in her world? Am I doing something I shouldn't be doing? So it's a way to help us remember all of these things that we don't want to be doing. I want to thank, of course, ALDF, student ALDF, the Center for Animal Law Studies, Pam Frosch, I see here, Kathy Hessler, I see, Joyce Tischler, Steve Wells, and of course, where's Liberty? Liberty Mulcahy, who organizes so many of these things to make it all work. And 2 administrative things. One is, there has been really a major shift in one of the interpretations of the rules of professional responsibility. When we get to it, we're going to slow down. We're going to talk about it more in detail. It's Rule 1.6 on confidentiality. There is a new ABA ethics formal opinion. They even put the word formal in the opinion that is going to affect a lot of us. So we'll spend a little more time talking about that. And the other is, part of my personal advocacy, is to do sumi paintings about animals. So for each of you, I have painted a pig, which is down here. If you would like one, at the end of the presentation, come up and get it. Now with that, we will start. Our lawyer's name is Billy Miller. It's always Billy Miller. She moves around the country. She has different practice areas. She does different crazy things, but it's always Billy Miller. Billy Miller is a lawyer and self-proclaimed champion of pigs, hence the pig. She loves pigs. She has a pig painted on the side of her VW microbus. See, I'm painting a picture here. The headboard of her bed is in the shape of a giant pig. She even has a pet pig living with her. Not a potbelly pig, but a 600-pound hog named Big Sam. When Billy is not helping animals, she makes a living as an intellectual property lawyer. Billy lives in the Midwest town of Prairie Heights. Prairie Heights' claim to fame is it has one of the last remaining stands of prairie grasses in the U.S. People come from all over the world, not only to see the grasses, but as scientists to study. I should write bigger. To study the effects of the grasses on carbon in the air. It is thought that planting these grasses may be one of the solutions to global warming. The town has an annual Prairie Grass Days to celebrate the grasses. There's a university extension campus in town that was created to study the grasses. The high school mascot, where Billy attended decades ago, is the prairie chicken. The hot issue in town now, though, is the closing down of a large hog production facility just outside of town. So there's a CAFO outside of town that just closed down. The land was gifted to the city when the owner of the hog farm died. The donor's will had a passionate statement about ending the confinement of hogs. So when he dies, he just gives it to the city. The transfer requires that the land must be used for educational purposes, whatever that means. The buildings and manure lagoons are surrounded by the stand of prairie grasses. All right, now we're starting to get into it. Environmentalists want to remove the buildings and lagoons and replant the grasses. The local dog community wants to make a large dog park in that location. The agricultural department of the state university wants to convert the hog production facility to a hog research facility, something that people like Billy aren't going to want to do. And the Chamber of Commerce wants to create a huge parking lot on the site to allow visitors to come and visit the grasses. All right, that's our setup. Billy has an animal blog with a corresponding website, Facebook page, and Twitter account. Billy got in the middle of the local controversy about what to do with the old hog production facility. She posted an article on her blog about what constitutes an educational purpose under the land covenant, because of course that's going to come into play on who gets to use the land. The blog started a war with each contingency weighing in, not only on their view about the best use of the land, but also with related attacks on each other of anybody who argued some alternative use than what they were promoting. Billy likes stirring up things in town. Once she even took Big Sam, remember the 600-pound hog, into City Hall and demanded that Sam be allowed to register to vote. Billy's argument was, after all, Big Sam was smarter than the then current mayor, and the mayor was allowed to vote, and so why couldn't Big Sam? This comes into play. Billy has disliked the mayor since they were lab partners in high school. Billy went to the Prairie Heights Humane Society meeting, so now there's a community meeting from the local Humane Society, where a plan of action to convert the land to a dog park is the topic. Randy Smith, the person who you're going to be hearing about a lot, Randy Smith, the executive director, led the discussion. The question came up of whether a dog park was a legal use of the land. Randy has known Billy all of her life and asked, "Hey, Billy, would turning the land into a dog park be an educational use?" "Sure," Billy said in a loud voice. Again, this is a big public setting. "Sure," Billy said in a loud voice. "As long as you're not charging a fee to use the park, then this would be a valid 501c3 use of the land." Actually, Billy had no idea what a valid educational use of the land is, and certainly had no idea how this term relates to 501c3 nonprofits. Billy slept through a law school class on nonprofit law. It was early on Friday mornings, and Billy usually went out drinking on most Thursday nights. All right, there's going to be 3 segments. We're going to talk about each segment. This is the one that will have the fewest number of issues in it because there's a lot of the setup. So amongst yourselves, talk about any issues that you see regarding Billy and the way she's conducted herself so far. Go ahead. Yeah, so people in the back come, make sure you can talk to somebody. All right, we're gonna bring it back around now because we've got a lot more to come. So what are some things that jump out at us? I'm sorry, go ahead. Yes.
She's giving a legal opinion and she has no expertise or knowledge in that area.
Right. All right. Now, there's a distinction here that we got to talk through. She's giving a legal opinion. Is she giving the legal opinion to a client? So let's talk about that. What does it take? She's at a meeting of the. Let's talk about first of all the bigger meeting, the meeting that she's at the Humane Society. She's asked the question. She gives an answer. Does that make that Humane Society her client? Who says no? All right. Surprise. That's probably a client now. So I'm going to read this like word for word out of the preamble of the Model Rules of Professional Responsibility, the big blue book. It says, most of the duties flowing from the client-lawyer relationship attach only after the client has requested the lawyer to render legal services and the lawyer has agreed to do so. Put another way, when you're looking at the opinions when state disciplinary councils have gone after lawyers, they say if somebody asks you a legal question and you give them a legal answer, you now have a client. Does that scare any of us? Yeah, it scares us all, right? I mean, think about holiday season coming up. Think about Thanksgiving. Think about cocktail parties. And you're the lawyer, and people come up and ask you about, well, I don't know, their divorce, their dispute with their neighbor over the property line, the tree overhanging, the whatever. And whatever comes out of your mouth next, if it's legal, if it's a legal answer to a legal question, you could well now have a new client. So that should scare us for a lot of reasons. What are some of them? You have duties to them. You have some pretty significant duties to them. Well, they're not paying you. There's always that. But does that matter? No, it doesn't matter. Money changing hand doesn't matter. Go ahead. They can sue you for malpractice. And let me tell you the scariest of all scaries, and that is, what happens if they ask you a question and the statute of limitation is getting close to run out? You've given them an answer. Then, let's say a year from now, they go to another lawyer, and they say, well, I talked to this lawyer, a while back, and they said, well, when did they talk to you about that? Well, and it's 3 weeks before the statute ran. Wow, you might have a malpractice claim that you really can't defend. So, this is surprising to most lawyers, and so again, reading it straight up, when you're asked a legal question, you're better off not answering it. You're better off, as a best practice, I'll put it that way, you're better off just saying, why don't you come down to the office or we can meet and we can talk about this, and then handle this person as if they are a client, because they could well be a client, and if you don't want them to be a client, don't meet with them. If you want them to be a client, do it in a setting where that you can do an intake form, you can ask a lot of questions about when did this happen, like the statute of limitations, on and on. All right, what else? How about the blog posting where she's just in there spouting off what a proper use is? Nobody's asked her for that opinion. Is that giving out legal? Does that get her into trouble? And on the blog posting, she might be acting as a private citizen. Let's say also she's got the big disclaimer at the bottom that we all see. This is not legal advice. If you've got a legal question, you've got to come to my office and talk to me and hire me. Do those disclaimers work? Well, here's the way it's coming down, and this is a pretty fluid area. So if it's just general comments, it's about something and nobody has specifically asked her a question, then it doesn't fit into this definition that I just read out of the preamble of the model rules. And so that's where you can start relying a little bit on those disclaimers. If it's just general hypothetical information, particularly if she was talking about, in general, this is what has to happen for a land conveyance, she's probably okay. If somebody now what happens if somebody posts a question in the blog comments and she responds? Anybody ever seen a lawyer do that on their website? Of course, we see it all the time. Would that fit the definition of representing a client? It well could. So, you don't take the time to do the input, you don't know about statute of limitations, you don't know about any of those things. When you click the reply button and you're acting as if you know everything and you're responding, you're probably practicing law at that stage with a client in public. There's just a lot of things wrong with that. So keep that in mind. Keep that in mind when you're out there in the blogosphere. All right, how about diligence rule 1.3 that says you have to act with reasonable diligence and promptness in representing a client when she's responding to the question posed by the executive director. It was an important person of that client asking, did she have an obligation to do more than just shoot off from the hip? Yeah, she clearly did, and she didn't, and that's straight up a violation. Does hey, I haven't really researched this, but let me just tell you what I think. Is that going to help you? No, it's probably not going to help you. All right. Let's move on to some more interesting things. Section 2, Billy took Big Sam. Remember, Big Sam is our huge hog. In fact, they say, remember, Big Sam is a 600-pound pig. Billy had removed the front seat of her VW microbus and put in an elevated platform for Big Sam to ride shotgun. Big Sam loved to ride with his head out the window and would accompany Billy whenever she ran errands. When Billy pulled into the Safeway, Mary Kimball, a PhD expert studying the prairie grasses, walked up to Big Sam and Billy. She asked, "So what does Big Sam think we should do with that hog farm land?" asked Mary Kimball. Billy responded, "Big Sam likes the idea of a dog park that allows pigs, but he would vote for replanting if pigs were not allowed at the dog park. Actually, anything is fine with Big Sam as long as it's not the Hog Research Center." Mary smiled and asked, "Billy, you're local, right? I mean, you were raised here." Billy answered, "Yep, family been here for 4 generations. Why?" Mary went on, "Well, a bunch of us prairie grass lovers were wondering if you could approach the city to see if we had a chance of taking over the land to expand the prairie grasses. We would love to tear down the hog farm and see how long it would take for the grasses to reseed themselves naturally. We're not connected in the community like you are, and we're not comfortable with approaching the city." Billy responded, "I did sit next to the city council member Jones in high school geometry. Jones did seem to be more interested in me than in obtuse angles. That gives me a bit of an in, I guess. I'll go poke around for you." It's worth saying that Billy was personally for anything other than putting a hog research facility in. To Billy, the win was keeping out the hog research facility. Really, she was happy that the hog farm in general was shut down. While getting Big Sam a couple of heads of cabbage for a snack in the produce aisle, Billy ran into Randy Smith. Again, we've seen him before, the executive director of the Humane Society. "That for Big Sam?" asked Randy. "Yes, he can use a healthy snack," answered Billy. Then Billy continued, "Hey, I'm heading over to the city council's office. Do you want me to ask how likely it is that the council will approve that dog park proposal of yours?" "That would be great, Billy. It would sure be nice to have you on our side. Your weighing in means something in this town." So Billy and Big Sam drove over to City Hall. Billy put a leash on Big Sam and headed into the city offices. When they got to the door of Council Member Jones's office, Big Sam started snorting. Big Sam could smell lunch. Not Big Sam's lunch, but Council Member Jones's lunch. Billy said, "Jonesy," that's what she called the council member, "Jonesy, Big Sam wants to know what it looks like for that hog farm land. Is it going to go to a dog park? Also, the prairie grass scientists want to know if it's looking good for the city to tear down the hog farm and reseed the site back to prairie grasses. I will tell you, no one wants to turn the place into a hog research facility, though. Which way is the council leaning?" Councilmember Jones said, "The council is getting a lot of pressure from the agricultural community to turn this into a hog research facility. Big Ag has a lot of power around here. But then the animal rights dog people are a loud group, and they all vote. The Chamber of Commerce wants the parking lot to bring in more tourists to the Prairie, and the Chamber council members certainly know how to pull political strings. Things don't look good for those prairie grass lovers, though." Big Sam did not like, remember Big Sam, the hog. Big Sam did not like the comment about Big Ag having a lot of power, so he snuck over to the council member's desk and took Jonesy's peanut butter and sandwich. It was gone in one bite. "Billy, get that damn pig out of here," shouted the council member. Billy responds, "Hey, Big Sam is a service animal, and he has the right to stay." Sam might have been Billy's best friend, but he certainly wasn't a service animal by any definition. Billy continued, but hey, let me give you $50 to cover the sandwich. Billy always keeps a spare 50 in her wallet to get Big Sam out of trouble when he's out on adventures like this and he misbehaves. All right. With that, let us know if you see any violations, and we'll be back in a little bit. All right, there's a lot to talk about in this one. There's a lot to talk about in this one, so let's come on back around. Maybe you haven't resolved it yet, but I think we've probably identified some of the issues here. So what's an issue? And I've been reminded to restate the question for the cameras and the recording. So, oh, that was just stretching. Yeah, that was Big Salmon over here. All right, what? Go ahead. Yes, conflict of interest. So So the question comes up, is there a conflict of interest? And of course, there is or could be. So what's the conflict of interest that we see?
She agrees to represent the very grass people and then tells Randy that she'll also speak to the mayor on behalf of dog park people.
Right, so she's going to the same city official to talk about proposals or interests from two different groups, and they are pretty much mutually exclusive. I mean, if you use it for one thing, you can't use it for the other. And so she does have a conflict. Now, is there in any universe that she could represent more than one party when their interests are in conflict? Is there a way that she could clear herself? Yes. What is that? She has to disclose it. So the question or the answer was she has to disclose it, but there's more than that. Besides needing to disclose it to both sides, what else does she need to do? Go ahead. Yes, she needs to get them to agree. I've also heard the term waiver. In writing, you have to have everybody agree that this conflict is okay. And there are some times when this might be okay to both sides. There are some times when this might be horrible. And so she can't just run around on her own saying, well, she's a facilitator, she's trying to help the animals, she's trying to help the environment, and so she can just do this on her own. She can't. At this stage, it seems pretty clear that she's representing both of these organizations, and she has a conflict. She's not disclosed the conflict, and she's certainly not gotten waivers or written waivers. All right, what else besides the conflict? Okay. Yeah. All right. So she's representing that this is a service animal, and it's not a service animal. Is the comment? And are we allowed to say, untruthful things as lawyers? Right, so the comment from the floor was, well, you can't lie to a tribunal. I mean, that's different from lying to your, to your friend when you're out doing whatever you're out doing. But if this person is a tribunal, you certainly can't lie to them. I will say that there's becoming more and more of a trend that says lawyers shouldn't be lying at all. So, watch for that on the horizon. Yes, I think that's coming. But for now, it's got to be a tribunal, and this was a council member, and saying that this is a service dog when it's not, at least get you into that range. So be thinking about that if you're not saying truthful things to anybody who can be considered a tribunal. In this case, it would be a council member. What else? A crime of moral turpitude. Explain. All right, so the comment is that she bribed a public official. So what you can't do is, you clearly can't bribe public officials. How does this, play in? Is paying $50 for the sandwich, is that bribing somebody so that this person will like her and her client's position more? Is this just this weird thing because she's hauling around a 600-pound pig into public offices? The comment is that she's sure it's not a $50 peanut butter and jelly sandwich. So let's back this up a little bit. What happens if she threw a $5 bill down? Would this get into the same realm of inappropriate conversation or interaction with a public official? All right, so the floor is almost universally saying $5 is okay, $50 isn't. And where do we start getting into a gray area when we're talking about Big Sam's mischievous eating habits? 15, I've got 10, I got 15, I'm the auctioneer here. Yes. $20, yes. There you go, more than the value of what she's replaced, and probably a little bit for convenience because, Jonesy can't go home and get a new sandwich now. So maybe it's the value of a sandwich if he went to places that sell peanut butter sandwiches. Maybe a good vegan community, and he can go down and get a sandwich down in the coffee shop. But who knows? So yes, so something about what a sandwich would charge downtown Chicago rates, let's say. What $50 might be it. All right. How about her own views? I put in here that, what her own views are. Can you represent somebody if your views are different from your clients when you're doing this advocacy kind of work? I'm getting lots of yeses. Sure, yes. Do we need to disclose it to our clients? No, the group is saying no. You're right. What do we need to do when we know that that our client is having us advocate for something that we don't personally believe? Well, there's obviously don't take the client, but what else can we do? Go ahead. Boy, the comment is act in your client's best interest, and of course, that's the answer. If you're doing the best job you can representing them, your personal thoughts, don't matter. And let's take it another way. Are you allowed to not take on a client because you think, boy, I hate what they're doing, and I just don't want to represent them? Do we have to represent people? No, we don't have to represent people based on their beliefs and our beliefs, and we can certainly accept the clients we want or turn them down. All right, do we see anything else? I'm going to throw out one other one that kind of was in here, but maybe not. Rule 4.1, truthfulness in statements to others. Transactions with persons other than clients in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact of law or to a third person. So, when we're out advocating, we've got somebody who's not a tribunal, but they're the somebody out there. We have to be truthful. A lot of us don't know this. That on 4.1 says if it's a third party and you're making a statement in your representation of your client, you have to be truthful to the rest of the world. Anyone ever seen a lawyer not be truthful when they're making comments? We see that in some advocacy work. I'm getting some laughs and smiles. So yes, so be careful about the comments you're making to people who aren't involved in either your litigation, your advocacy work, maybe the press, people like that. You have to be truthful under 4.1. It's something that we don't talk about much. All right, so the big change thing, let me talk about that. Rule 1.6 on confidentiality has been misunderstood by lawyers almost forever. So what lawyers have a tendency to think about confidentiality is, I have to keep my client's secrets a secret. But that's not what the rule says at all. What the rule says is that you have to keep confidential anything you learn from your client. And so what about things that you file in court, public record? Anybody can go pull it up. Something that your client has spoken about, something your client has written, it's out in the public. Are you allowed to talk about those issues? The answer is no. And this shocks almost every lawyer that I bring this up to. In fact, I've been challenged on it enough that when I bring the big blue book, I open it to the page where I can read it, where it says exactly that. But just to drive this home, just recently, the American Bar Association made this as clear can be so if you're going to write anything down, it's Formal Opinion 480, which came out on March 6, 2018, Confidentiality Obligations for Lawyers Blogging and Other Public Commentary. The first sentence, lawyers who blog or engage in other public commentary may not reveal information relating to the representation, including information contained in a public record, unless authorized by the provision of in the model rules. So, you can't talk about anything your client tells you ever unless one of two things. There's some exceptions, like they're going to commit some crime, like they're going to kill somebody. You can certainly use whatever they tell you so that you can represent them. But just in terms of talking, you can't do it unless you have their permission. This is such a big shift in the way most of us practice law that as a best practice, I would recommend you think about this and maybe even add some language in your engagement contract that talks about what you can talk about and what you can't talk about. So think about it. Think we go to bar association things. We talk about this interesting case we have. And you don't say who it is, but you're talking about information you learned from the client. Is that a violation? It could well be a violation. Clearly, if you're blogging about it, this comes straight out and says that it's a violation. There's another pithy quote from this that should scare us, so I'm going to read it. This confidentiality rule applies not only to matters communicated in confidence by the client, but also to all information related to the representation, whatever its source. Whatever its source. You can't talk about your client's cases to anybody unless you need to stop them from committing some major crime, you need it to represent them, or you have their permission. So seriously think about finding a way to pick up that permission or just stop talking about your client's cases. Mm-hmm.
But they list the names of the clients, more or less without their permission. The client knows you represent them, but didn't say you can expressly listing on this website.
All right, so the comment or question is, what about sites, and we all know their name, where you list representative clients? I will say there was an ABA, how to do it kind of fact sheet that was out last year that was talking about good practices, do's and don'ts on web pages, and I went to pull it up, and it's been pulled down. And in that, they were talking about that would probably, violate confidentiality. I think in the way all of this is going, that would violate confidentiality, even naming that they're a client. Again, think about a way to clear this, And it also, just as a best practice, there's nothing wrong with sitting there talking to your client about, hey, is it okay if I talk about this case to bring in some other ideas? Let's say if I need to talk to some colleagues or a law professor or something. And they're probably going to say, sure. Is it okay if I talk about, this when I'm, at Thanksgiving at a cocktail party? They're probably going to say no. And then you say, okay, well, you can't do that. And so it's probably worth the conversation up front just to get this nailed down. So this is a fast-moving area of law. Again, when I tell it to lawyers, they scratch their heads and they say, oh, this must not be right. I'm telling you this is a major shift, and it's something that you need to pay attention to. I mean, for the ABA to come out with this special, and it's a long opinion that talks just about this, it tells me that there's a change. By the way, it's not a change in the actual rule. The rule has not changed for a long time. We just didn't pay that much attention to it, but now I think we do. Yes? So the question is, what happens if you make it a hypothetical? There are comments that says, if you're an educator, and you're talking about hypotheticals, you can still do that. But just saying, so let me tell you about the hypothetical case, and then you start going into your representation, I think that would get you into trouble. If the Bar Association found out about it, I don't think that would clear you. I think if you were truly doing it in an educational format where you're combining 2 or 3 different clients, changing the facts around to talk about things, I think you're fine. So we just can't talk about our clients the way many lawyers have talked about clients in the past. Yes? What about prosecutors? So the question is, what about prosecutors? So prosecutors, are prosecutors have a client? Are they lawyers? Of course they're lawyers. Of course they have a client. Of course they're covered under this as well. So now there are ways that you can talk. Prosecutors can talk to each other. If they're trying to gain some insight about how to handle a case, then this is something you're doing to carry out your representation. But the prosecutor convention, where the open bar has been going for 3 hours, I think you're probably in trouble. Yes, one more.
So the ABA model rules are obviously just model rules, and so I'm wondering whether this is applicable in real life, because I know some states don't adopt the model rules. I don't know if any states actually adopt the ABA rules. Mm-hmm. So I was wondering if you knew.
Well, almost all states have adopted most of the model rules, but it's an exercise. So the question is, what about this in real life? Because we're not talking about the ABA model rules. What we're talking about is the rules that regulate us wherever we practice. And so the straight up answer is you would have to look at what's going on in your state. I will tell you this is fast moving enough that there may not be any pronouncements or disciplinary proceedings on that topic in your individual state. I suspect that those bar disciplinary councils are going to be looking at this model rule. And again, if you straight up read the model rule that hasn't changed for a long time, it says that you can't reveal information that you've received from your client. So, so yes, there's a technical difference between the ABA. The ABA does not control you. It's your state law. It's your state disciplinary council. But I also tell you that I think that this is where most states will end up, or if they don't like it, they'll just pitch the rule. I mean, that could well be. I could well see states that like to write, like California. I can well see, it just getting tossed and they write a whole new rule. So this is fast moving. Just be really careful about it. All right, with that, we're going to move on. Section 3. Billy went home, fed Big Sam a proper meal, and then sat down at her computer. She reported out on the World Wide Web the council member Jones what he told her. Her site exploded. The prairie grass lovers are furious that Billy talked about anything other than prairie grass restoration when she went to see the city council member. The local farm bureau started a smear campaign against Billy for not supporting hog research. The dog park contingency wanted to know why Billy did not do a better job representing them and all of the dogs in the city. And an anti-animal rights group posted unthinkable comments about Billy and Big Sam. Billy is fed up. She posts, "Anything other than a hog research facility is a win in my book. If you think I represent any of you, I don't. If I represent anybody, it's Big Sam." Then she took a shot at the mayor, whom she didn't like. And Mayor, I did not like you when you tried to kiss me under the bleachers in sophomore year, and I don't like you now. And then you can all go F yourselves. Peace out. The next day, Billy reads an article from the ABA regarding lawyers posting on the internet. She decided to play it safe and took down all of her internet presence. A month later, it's time for the Prairie Grass Days Festival. The city, which now owns the abandoned hog farm, decides to hold the festival at the hog farm site. During the day, there are lectures on prairie grasses. Nonprofits set up tables alongside of carnival booths. Billy and Big Sam stopped by the Humane Society's booth. The executive director of the Humane Society gave Big Sam a nice ear scratch and asked Billy if she minds going into town and picking up a couple of extra folding chairs. A hog farmer accidentally ran over all of their chairs as they were entering the parking lot. Billy said, "Sure, Big Sam always likes to ride into town." The director reached into the donation jar and gave Billy 5 $20 bills to cover the chairs. Billy stuffed the bills into her wallet and headed out with Big Sam to buy the chairs from Walmart. At night, the band Pure Prairie League, and I looked it up, they are still performing and have an open calendar, took the stage. Billy and Big Sam pulled up a seat with the other animal people. Of course, Big Sam considers himself an animal person, and started drinking prairie beer. It really exists. Randy Smith pulled up a chair next to Billy. Remember, Randy Smith is the executive director of the Humane Society. Around 10 other Humane Society members also joined them. Just before the band kicked off with their 1972 hit Amy, the discussion turned to possible use of the abandoned hog facility as a research facility. Maya Trevor, a Humane Society board member, so this is a board member, said, "If they don't turn this thing into a dog park, we should just burn the place down." Then the discussion turned to how you could do that without hurting anyone or burning down the prairie grasses, or really how to do that without burning down the entire county. Billy jumped in. "Hey, whatever you do, don't get caught. The penalty for arson is a Class B felony, and you can go away for up to 25 years. The band played on, the prairie beer kept flowing, and Billy and Randy Smith got what can only be described as drunk. At night's end, Billy called Uber, but it's no surprise that they don't have any cars that can accept a 600-pound pig. Then Billy remembered she drove her VW microbus to the festival. So Billy and Randy tucked Big Sam into his bed in the front seat. They climbed in the back. They pulled the window curtains closed. And how did they used to say it back in the day? If the vans are rocking, don't come knocking. All right, let's talk about this final section before I tell you how it all worked out. All right, I'm going to end it a little early so that we can end on time. So these should jump out at you anyway. So what's an issue? What's one issue? Sex. So just a one-word response from the floor is sex. All right, drinking. Well, let's talk about sex. So this is, let's say, clearly a client. If getting around if she, withdrew or whatever. Let's assume that's a client. The rule isn't what most people think the rule on sex is. Oh, and by the way, the state of Louisiana doesn't have the prohibition of sex with clients. Either does Canada, which I find interesting. But most places in the U.S. do. What the rule says is that you can't have sex with a client who you didn't previously have a sexual relationship with before you started representing them. So as one clever law student pointed out, as soon as you go volunteer for a nonprofit, look around for all the people you might someday want to have sex with them before you give any advice and move forward. I'm not really sure that's the spirit of this thing, but there is some sense to this. I mean, as a person, aptly said, well, what about your partner? What about your spouse? Well, sure, I mean, we can all represent our spouses when we're out doing things for them, and you would think that there'd be a sexual relationship. There may or may not be, but yes. So the rule is a little more complicated than most of us think. All right, what else besides sex? I'm sorry? Safekeeping property. Boy, I haven't ever heard anybody say it that succinctly. But yes, the commingling of funds, the safekeeping of property. If you're receiving client funds, you need to safeguard it. You need to keep it separately. You need to account for it. Just shoving it into purse or whatever isn't going to work. I will tell you a best practice, again, because I've seen a lot of this happen, while out there in the field. We, as lawyers, we're trusted. We are often sent to do things for our clients where we can go run an errand that involves some money. Here's the best practice. Go buy whatever they want you to buy, put it on your debit card or credit card, and then get them to reimburse you. So you've never commingled anything. You've never had to safeguard their funds. It just makes it cleaner. So a best practice is don't try to even begin to keep it separate. Just don't ever keep it, and then just come in after the fact. That works every time. Keeps you out of trouble on this every time. What else do we see? Yeah, she gave legal advice about arson, and you're not allowed to help. You're not allowed to help people commit crimes. It's just right up there with the things that can get you disbarred, and so don't do that. If you start and now the joking subsides a little bit because I've been in this situation. I've been in situations where animal rights, animal welfare groups start talking about committing crimes, and I've got a best practice for you. So if that happens, don't try to engage. Don't try to be funny. Just say, don't break the law, stand up, and go someplace else. I mean, anything you say will not be remembered right, it won't be interpreted right, and you have no control over somebody going crazy and really hurting somebody. So just say, don't break any laws, get up, and just leave. So best practice. That happens, just leave. It will save you. It could save you. That could literally save you your bar license. All right. What else? Yeah, don't do that. All right, well, with that, because we've only got 2 minutes, I'm going to read how it ends. Anyone want to know how it all ends? How it all ends. The city could not decide what to do with this land, so they put in a dog park, they built a parking lot for tourists, and they put in an interpretive center for the prairie grasses. Now, Big Sam is the hero of this tale. The video of Big Sam trying to register to vote went viral with over 3 million views. So now, Billy, Randy, and Big Sam take road trips to animal law conferences and get out the vote rallies where Big Sam is the pampered guest. They take the VW bus, Billy drives, Randy Smith sits in the back, and Big Sam still rides shotgun with his head out the window. So thank you. Don't be Billy. And if you're interested, come and get a painting. Thank you.